Hello everybody and welcome to this seminar with Claire Archibald all around GDPR and compliance within school. Claire works for a legal law firm, Brown Jacobson, and is a specialist in GDPR. So hopefully she'll be able to answer some of the really interesting questions that we've had submitted in the past week. Hello Claire.
Hello, thanks so much for having me. Really nice to meet you all as well. Thank you.
Absolutely. Thank you for being on here as well. So we've had some really interesting questions emailed in. So I'll kick off if that's okay, because I'm conscious it's only quite a 30-minute webinar. So the first question we've had is, are we allowed to give out names of children for birthday invitation purposes?
So yeah, it's a really good question. This is a nice question to start with because I'm going to talk about lawful basis when it comes to processing data. So, data protection 101, so starting from the very beginning, every time you in school do something with some personal data, when you process it, that means whether you store it, whether you share it, whether you delete it or whatever, that's processing. Every time you do that, you need to have what's called a lawful basis under the GDPR. And so that means a lawful reason. So you need to identify the reason why you are processing that personal data. Now in schools, you process a lot of personal data, and that's because you have to. That's your function as a school. Some of that information you process because you are legally obliged to do it. So a good example is the information that you share with the Department for Education as part of the school census, and the daily attendance information that you share via WAND with the Department for Education. You are legally obliged to share that information. You have to do it. You have no choice. And there are other aspects of processing that, again, that you have that legal obligation. The majority of the processing that you will do in your school is under what's called your public task. You are there, your public task, you will receive public money to deliver a function, which is the education and safeguarding of children. So that's your second big legal basis. Your next legal basis then that you have is contract. So you employ all of your staff under a contract of employment. And so you process their personal data as part and parcel of employment. So, you have their bank details so you can pay them. That's part of the contract. You're also under legal obligation with relation to some staff data. So you have to provide their information to the HMRC so they can be taxed appropriately and so on and so forth. So the majority of the processing that you do in schools either falls under legal obligation or public task. Then there's other things such as, if you need to give a health worker some information, this child is diabetic and it appears they have fallen into a diabetic coma, you need to do something to save their life. The lawful basis for that would be vital interest. And so what you need to do every time you decide to share some information, you need to think about your lawful basis. And one of the lawful bases is consent. And so you're thinking then about publishing children's photographs on your school website. Obviously, you're a school website producer, so this is very relevant to you. And so you're thinking about that lawful basis. When it comes to giving out names of children for birthday invitations, you have to still think about that lawful basis, even though it's nice to do. And it seems like, well, we've always done this, we've always shared people's information. You still need to go through the rigor and think to yourself, what is the lawful basis for sharing that information? You're not legally obliged to share it. It's not why you exist as a school. You don't exist as a school to organise play dates and endless soft play centres. And so you go down all of the lawful basis until that only really leaves you with one lawful basis, which is possibly consent. And so really, are you allowed to give names of children out for birthday party invitations? Well, only if you want to go to the trouble of getting consent from everybody to share that, because there is no other reason why you would have to share that information. So that is a long way of answering that question, but you can see that it doesn't matter what you're doing, you still need to go through the rigor. And so what I haven't mentioned the relevant article, the relevant bits of legislation here, but this is Article 6 of the UK GDPR, and you need to go through those options and work out which one fits. And as I say, even though it's just one of those little things that seems ancillary to what you're doing as a school, you still need that lawful basis.
No, that's really interesting. interesting. And, you know, there is, I suppose you kind of come into that question not really knowing. You probably do know about the lawful basis, but then you think, oh, but, you know.
But this is different. No, it's not different. It's exactly the same.
Yeah. Okay. Number 2, if a parent asks to see their child's record on CPOMs, can we show this?
Okay, so this, I mean, you know, we've designed these questions in a way to flow on from each other. So we've started off talking about lawful basis, and then of course we're looking at parents then accessing. So parents, you know, again, you still need a lawful basis to process this personal data. But data subjects also do have rights in relation to their personal data. So when it comes to the information that you capture on CPOMs, data subjects have the right of access to their personal data. So that everybody, I'm sure if you work in a SAR, unless you have been the most lucky school in the whole of the UK, I'm pretty sure you will have all dealt with subject access requests over the last years, and probably increasingly so in the last couple of years. Thank you for nodding, Hilary. I'm glad you see that extra workload. The subject access request. Now, subject access requests are a right of data subjects under the GDPR. That right belongs to the data subject themselves. So in relation to children, children's rights of access belong to the child. Really important to say that. That is a child's right. It's not a parent's right. Parents do have rights in relation to access to information, and I'll talk about that in a minute, so I'll just pop a pin in that. But let's just really focus in on children's right to their personal data. Now, when children are little, or when they're not competent, is the formal way of saying it, parents can access those rights on behalf of the child where it is in the child's best interest to do so.
Okay.
Once a child becomes old enough to exercise their own rights, that's usually around 13 years old, could be older, could be younger, then that right passes to that child and they exercise it themselves. So it's really important to say, so bringing it back to the question, if a parent asks to see a child's CPOMs, can we show this? So if it's a subject access request, that right belongs to the child. So the first question you need to be asking yourself when a parent asks for information about the child is, am I satisfied that this parent is accessing this in the best interests of the child, or is the child old enough to exercise their own rights, in which case should they be either exercising themselves or giving consent for their parent to do that on their behalf? So it's really important to start off with that question, and it's very often we can completely forget about that and start thinking about redactions and you know, did this child say this, and are they happy for their parent to say it? The reason why it's really important to say that is that very often parents want to see this information in pursuance of their own agenda, not in pursuance of, you know, look at representing the child. Does that make sense?
Yes.
Yeah. And so this is where you very often get to see, you get requests for access for information from non-resident parents, or because mum and dad are having a big dispute and one of the parents wants to take the CPOM's information to court and use it against the other parent. Well, that's not exercising it in the best interest of the child. So do take a moment to ask yourself that before you proceed. So say you are satisfied, either, you know, that yes, the child is the parent is asking for this information, and, you know, we're happy that either, you know, it's definitely in the best interest of the child, or the child is old enough and the child agrees and consents. Then when it comes to CPOMs, there are a number of really careful considerations, and we know that the information in CPOMs is going to contain lots of information, some of which is really not suitable for sharing onwards. And this is when you start to think about applying the data protection exemptions to the right of access. Now, the ICO website has a very detailed guidance on the right of access and goes through all the exemptions. And so it's really, I would really urge you, when you're thinking about exemptions, to go and have a look at that, because there are so much more exemptions than you think there are. So the one exemption that everybody knows and everybody's pretty good at is, I must remember to redact other children's names from this CPOMS log. You know, I'm going to disclose this. I don't have a lawful basis to disclose, you know, the name of another child or information in relation to another child. So it's the third party exemption. And there's lots of different nuances around that. Sometimes you have to get get people's consent. Sometimes you might decide that it's reasonable to disclose that without their consent. So information in relation to a teacher is usually, the law says that's reasonable to disclose without their consent because they're an education worker. But there's other exemptions that will apply too. So child abuse data is one of them. So if their parent is asking for information and on CPOMs it relates to child abuse, and it would be made by that parent, and it's clearly going to risk that child if that information was to be disclosed, then you've got that situation there where you can apply that exemption. So a parent, there's lots of questions to ask before you decide whether you're going to disclose that to the parent. And then when you get that information, if you're happy, then okay, the parent has that right. Then you go through and you think very carefully about exemptions. So removing third-party data where necessary, and then thinking about risk of harm to the child or anybody else for that matter. And as I say, lots of exceptions. We've not got time to go through all the exemptions today. So that's the child's right, that's subject access request rights. There are some parental rights in relation to education. And so if you are a maintained school, I don't know if any of you on the call today are in a maintained school, brilliant. So you've got the pupil information education regulations that apply to you. And that is about a parent's right to see an education record. So that parents can ask to see that education record, and CPOMs, it's a little bit vague as to whether CPOMs comes into the definition of education record or not, but you need to make a decision about that. And again, you should still be applying exemptions. You shouldn't be disclosing anything that could lead to risk of harm of a child. And then if you're in an independent school or an academy school trust, then the independent school standards apply to you. And really, parents don't have that same ability to access the education record in an ongoing way. They only have the right for an annual report. And so you don't have that, and that's a really important distinction, because very often I'll get academy trust clients where a parent has made a request for information under the education information regulations, but actually that doesn't apply to an academy. And going back to what I said before about lawful basis, well, actually you don't have a lawful basis then to share that information with the parent, because that piece of legislation doesn't apply to you. In relation to requests under subject access request information, sort of subject access request, then if somebody's unhappy with how you've responded, they have the right to complain to the Information Commissioner's Office. However, in relation to education records for maintained schools and the annual report for the academy and schools and independent schools, you don't have the right to complain to the Information Commissioner in relation to that. They can only follow the school's complaints process. The Information Commissioner doesn't look at those sort of requests. So you've got two slightly separate channels there, but hopefully you can see how these differ.
It's really tricky, isn't it? Like,
it is.
When you're dealing with it in that kind of situation, it's tends to be like a parental complaint, and actually it's quite a stressful situation for a head teacher to be in, and then navigating that is complexity, isn't it, to understand what access you can give them and what they can see.
Yeah, and as I say, it's really important to understand under which regime who the right belongs to. And the problem is, of course, when parents send in these requests, they can sometimes be a little bit unclear themselves, and they might say something like, I'm making a freedom of information request for all my child's information, and then so you really don't know what legislation you're working under. So do take the time to really make sure you understand the request and go back and clarify it if you need to. Don't make presumptions about the regime that the parent wishes to apply. Again, there's some good information on the Information Commissioner's website that talks about children's data, so you can direct requesters back to the Information Commissioner's website and say, here's an explanation of the two regimes, which regime is it that you want?
Yeah, no, lovely, thank you, Claire. So third one, CCTV. Can we watch back incidents involving children on CCTV? What if a child complains about this?
So this is a really good question, and again, something I've seen lots and lots of times in schools. So CCTV is incredibly pervasive throughout schools these days, and what I often see is that kind of like they have maybe one camera on the door, and then over the summer holidays they think, I could really do with an extra camera. Oh, and an extra camera. And then it kind of creeps up on a school, and then, before they know it, they've got lots and lots of surveillance all over the place. It's really important that CCTV is managed through a CCTV policy, and you should follow what you say in the CCTV policy. So that should set out the purposes for your CCTV, and then you should be following your procedure, because obviously the governors or the trustees will have, authorised the use of CCTV under that policy. The other thing that's really important when it comes to doing your CCTV is doing your DPIA, your Data Protection Impact Assessment. Really important piece of work where you can look at the purpose for the camera or the cameras or additional cameras. So you should be, doing one every time you add some more cameras on. And then really looking at the purpose and understanding then who's going to be authorised to access that, under what circumstance, how long you're going to keep it, and so on and so forth. It's also talking about things like transparency. And one of the things I notice in schools very often is that schools can be very good at remembering to tell adults that they're under CCTV, but they sometimes forget to tell children. And children have just as much right to transparency as adults. They're just smaller people. So signage might need to be a bit lower. The number of times I've gone in and I've seen signage very high up that no small child has got a chance of seeing, or signage that really isn't very accessible to children. And so really making sure that signage is understandable and viewable by children, so that they understand that they're being surveilled while they're in the playground or in the corridors or whatever. So in relation to the question, can we watch back incidents involving children? Usually your CCTV, most CCTV policies say that, the purpose of the CCTV is for the health and safety and security of children, staff and visitors. So watching back on children's incidents is part of that process, usually checking to see what's happened. And what to do if a child complains about this is, again, you shouldn't be in the position where a child is suddenly very surprised and didn't realise that there was CCTV in the area that they were in. They should be aware of this. And then the next question that kind of comes from that then is around accessing it and sharing it with children. Very often children don't believe what they've done, or their parents don't believe what they've done until they see that footage. And so, actually viewing something on CCTV can be kind of like a really important part of helping children to realise the consequences of their actions and how they might have behaved. And so viewing it within the school environment could be, a pragmatic way of dealing with a child that doesn't believe they've behaved in a certain way, or a parent. The issue is then when you get these subject access requests and people then want to have a copy and want to take a copy away, you need to be really sort of aware of other people's privacy, making sure that you're applying redaction and removing kind of identifiable features of other people that might be in that footage, unless of course it's reasonable to do so, or you have their consent to share that information.
Yeah, no, that's really interesting about the signage being at children's height, and also in terms of the readability of that text as well. If you're a child and want to understand the CCTV on the premises. Okay, this is an interesting one. All members of staff have access to CPOM/the MIS system, but we have reason to believe one member of staff has used this knowledge and told other members of the school community confidential information. What should we do, and who do I need to tell?
Okay, so going back to my data protection 101, so we talked about lawful basis when we talked about data protection. We're going to talk about the data protection principles. And the data protection principles are that, data should be processed lawfully, transparently. So we talked about lawfulness, we talked about being transparent, we talked about being fair. And so, there are other data protection principles around security. I'm going to pin down on the security one now. So having secure data processing means that you should have a variety of technical and organisational measures to make sure that the right people in your school have the right level of access to the right systems. And so the first thing that strikes me in this question is that we've got all members of staff having access to the CPOMs and MIS. And really, you should be using your technical measures here on your CPOMs to make sure that only the people who really are authorised and have the responsibility to do so, basically your designated safeguarding lead team, should have that access and be able to view all of those records. Yes, you'll have lots of staff who need to be able to have the ability to enter information into CPOMs or select information on the management information system, but you shouldn't be giving everybody the same kind of level of privileges. And you should be keeping, and I can see lots of nodding faces, which is good. So you all know this. It's about having, I think they call it basic level access in CPOMs and then DSL level access. I can't remember the term for the enhanced level. And so really reviewing that, and part of the responsibility of your business staff and your DSL team and your data protection officer has got to be to keep that list of people who've got access to these systems under review, and auditing around that as well. So again, making sure that staff are only accessing for legitimate reasons. So, somebody's auntie or next door neighbour shouldn't be popping in to see what's been going on. And, I saw there was a police car outside my neighbour's house last night. I wonder what that was all about. I'll have a little look to see what happened on CPOMs. And so, so it's really around that. So in this instance, if you've got one member of staff who's accessed this information in an unauthorized way and then moreover told other members of staff this confidential information, you've potentially got a data breach situation on your hands. And so then again, I'm sure you've all had a data breach in your schools, so this is not new to you. This is around assessing the level of risk of harm to data subjects as a result of this data breach, and deciding, number one, what you need to do to mitigate the breach. Number two, do you need to report this to the Information Commissioner's Office and potentially to data subjects themselves as well? So lots of things there. You should have a data breach procedure within your school that you should follow. And then, of course, I think you're going to be looking at your HR route here in terms of this staff member, in terms of the disciplinary process. I'm really conscious that we're running out of time, and it's going to lead me really nicely into your last question, Clay. So I'm going to pick up an aspect of this last question.
Okay, so has there ever been an incident where the ICO has taken action against a school, and what was the result and why?
Yeah, so I'm going to talk about 3 incidents here in relation to schools and action that's been taken about schools, but I'm just going to tie it into the last question. This is action that the ICO has taken against an individual, not in a school, but definitely lessons from school. So there was a chap called Christopher O'Brien. You can look him up on the internet. Christopher O'Brien was a health-related worker, and he was helping himself to health records in relation to people that he knew. He was looking at people he knew. He was a health worker. He was looking up to see what was going on with friends and families' health conditions, and he was prosecuted by the ICO for this and made to pay compensation to each of the individuals whose files he viewed. So again, that bringing on that staff confidential information, you can see that last example really could, there could be a prosecution against an individual if they are helping themselves to information that they are not authorised to do so. So tying it back into schools and action against schools. So no school has ever been fined by the Information Commissioner. I think, when we go back to 2018, we talked a lot about fines, didn't we? And there was lots of worried schools saying, am I going to get a fine? No school has ever been fined. It's not the regulatory priority of the Information Commissioner to fine public authorities, including schools, but there has been action against schools, 3 notable ones. So, and these are all what's called a reprimand. So this is like a public telling off, basically. A public telling off for Chelmer Valley High School, who implemented facial recognition technology without doing a DPIA in advance. So they got a public telling off. One for Parkside Community School, they displayed information on a whiteboard. So again, CPOMs, they had the CPOMs log on the teacher's laptop, and he projected it onto the whiteboard, and then pupils in the classroom saw what was written within CPOMs. And then we had one for Finham Park Academy. They had cybersecurity incidents. They'd actually had 3 incidents previously, and they'd reported them all to the Information Commissioner. The Information Commissioner had made recommendations in terms of how they could improve their cybersecurity, and then another one happened, and they got a reprimand because the Information Commissioner said what was particularly aggravating for them was that they'd had these things happen before. The ICO had given them advice as to what to do, and they hadn't taken any action. They hadn't improved things. They got a reprimand for that. So, as I said, giving you a whistle-stop tour, again, no individual action against school staff as yet, but there has been individual action and prosecutions for individuals in other sectors. So there's no reason to believe that that couldn't happen to a member of school staff as well.
Thank you, Claire. The final question, Catherine has just messaged. Can you tell us how long we need to keep personal information, digital and paper, before it's destroyed, e.g. registers, children's personal data in SIM, staff records, etc.?
This is a really, really big question. I definitely can't do it justice in 3 minutes. Really what I'm going to say, every school should have a retention policy and a retention record. If you join the IRMS, I actually delivered a session to the IRMS schools group yesterday, and we talked about this for an hour. It's a really big decision. So IRMS does have a model retention policy, but each school should be making decisions. There are some statutory requirements, so information on attendance records and admissions records. You have a legislative requirement to keep that for 6 years. There are also other legislative requirements in terms of retention, but really you need to do a big piece of work around your retention policy and make sure that you make those decisions and get expert advice. I'm very passionate about records retention, so if any schools do want to and have run several records retention projects with multi-academy trusts in particular. So if schools want to engage with me to get like some good consultancy work around that, then I'm more than happy to help. But that's all I can kind of give it justice to in 3 minutes.
Makes sense. Thank you so much, Claire. I've learnt loads just from
Hopefully.
your point of view. I think it's been really informative.